Have you with us tonight here on the Newsfeed Late Night. We continue now with your reporting and we turn our attention to the pandemic. Can employers institute disciplinary measures or even dismiss an employee who flouts COVID-19 regulations outside of work? Well, senior legal advisor of Strata-g Labor Solutions, Hattingh, believes so, and he joins us to unpack this. Justin, good evening, and thank you very much for your time tonight. Can my employer, in simple terms, fire me for attending a funeral, which is viewed under the regulations as a super spreader?
Good evening, and thanks for the opportunity to chat to you this evening. Now, I'd just like to start off with talking about dismissal for misconduct during work hours and then also after hours. Now, generally speaking, as we know, an employer is only entitled to take action against an employee if they breach rules and regulations during work hours. However, there are certain times when off-duty misconduct, as it is known, may then give rise to situations where an employer may take disciplinary action against that employee. Now, those particular instances would be when the employee does something which actually impacts on the employment relationship materially and might then affect, say, the profitability, efficiency, or even the operations of the business negatively. Now, going on to the issue of COVID-19, as we know, there are a lot of regulations that have been put in place by national government to contain the spread and to ensure that there is, proper guidelines and people are keeping themselves healthy and not exposing themselves unnecessarily to the pandemic. Now, if I flout those regulations, for instance, and I go on social media, I'm having a party, I am exceeding the occupancy of my home or my club or whatever it might be, and I'm posting these photos and it somehow gets linked to my employer because someone goes onto my social media profile, it could have a negative impact on the reputation of the employer. I come to work, I expose other people to that illness, they get infected, and then it affects operations. And that might then give rise to a situation where an employer may take disciplinary action against that employee.
What is the threshold of what is viewed as recklessness as far as the employer is concerned?
So in as far as recklessness, I mean, we all know that we need to make sure we at least wear our mask, keep our social distance, and that we are sanitizing. So if I completely decide that now I'm not going to follow those regulations, I'm not going to wear my mask, I'm going to basically not keep my distance from anyone, I know what the consequences of that would be. I know people could be infected, become ill, possibly in very serious cases even die, and I still go ahead and act in that manner. That would be considered so negligent that it's actually reckless.
The Occupational and Health Safety Act, though, puts onus really on the employer to ensure that the place of work is safe. Now, under the COVID-19 regulations, the Department of Labor, if I remember well in the conversation that I had as we were opening up with them, put the onus on the employer, for example, to test and ensure that the employer answers a questionnaire that would then indicate where they've been and who they've had contact with and so on and so forth, so that then they can make the determination of whether or not it is safe to bring the employer into the place of employment. Now, if that process was followed and I am in a place of employment and I was cleared by those processes and it so does happen that a picture of me appears and I was in a gathering of some sort, what are the implications there?
So, as we know, the Occupational Health and Safety Act does place a duty on employers to make sure that they provide a safe and healthy working environment. However, there's also a converse duty on employees then to make sure that they actually comply with regulations and then also make sure that they are truthful in their reporting when they come to work. It could so happen that someone is not sure where they were infected, but then when it comes out that, as we were just speaking about on social media, this person was at a party not adhering to regulations and then subsequently there's an outbreak, on a balance of probabilities you could probably then say, well, okay, this person, they put themselves in a position that was not safe. They then subsequently become infected. they come to work, they might have been cleared, but as we know, it has an incubation period, and then they subsequently test positive. Suppose on a balance of probabilities, it would seem then that that employee was the root cause of that super spreader event, and then you could likely take action. But once again, being able to take action against an employee presupposes that you have proper policies in place, that employees know what constitutes misconduct, they're aware of it, and then if they still continue to contravene that, then you'd be able to take action.
That is very important, isn't it, Justin? So you're saying, firstly, there has to be a policy in place. Secondly, the policy has got to be communicated to the employees, and I suppose there needs to be a degree of certainty that they understand what the policy actually means.
Absolutely. As I was saying before, the Labour Relations Act and the Codes of Good Practice require that for something to be substantively fair, so the reason for any sort of disciplinary action requires employees to at least know what the rule is. There needs to be a rule in place, and it must be reasonable. I mean, I don't think we can disagree that it's reasonable for employees to make sure that they adhere to COVID regulations and that they ensure that they do their part in ensuring a safe and healthy working environment. Because let's think about it. If someone is ill, not only does it affect them, they go to work, they infect other people then might need to take time off, they might need to be hospitalized, and that could end up affecting their earnings, their livelihoods, and ultimately the business might have to shut down for a day or two in order to do a deep clean, which then affects the business as a whole.
Yeah. In your language, I suppose they would ask, is it a dismissible offense? And what makes it a dismissible offense? Because I suppose disciplinary processes can be a warning, can be a written warning, a verbal warning, and so forth and so forth. So does this constitute a dismissible offense?
So if we look at it, I mean, every dismissible offense or every offense which results in dismissal is weighed on its own merits. So we need to see, okay, what was the contravention? How serious was it? And ultimately, does it justify dismissal? Is it reasonable? So if we look back at the COVID-19 regulations, this is basically a national law. You could be contravening a national law, which could be a criminal offense. On the one hand, also, you're contravening a workplace policy, a workplace rule, which is put in place to ensure the safety of people's lives and livelihoods. And if you do not follow that rule, and it ends up costing someone their life, it ends up creating serious illness and severely halting the operations of a business and causing financial loss, you could then possibly argue that that is extremely serious, and then you'd be able to then dismiss an employee in that instance. However, if someone is just caught maybe walking from their desk to the bathroom, they forget to wear their mask, that is less serious, and it might have been a lapse in memory and judgment or whatever it might be, and then you could possibly then, in that instance, give them a warning.
Yeah. Can they be disciplined to the extent of, for example, unpaid leave, where it now begins to affect them economically? And this is a question that has come up before, to say, well, should my employer find out that probably I could have been exposed? Can they say, well, you'll go on unpaid leave because I just can't take the risk?
Okay, so when we talk about unpaid leave or unpaid suspension as a sanction, that always needs to be as a result of going through a disciplinary process. There needs to be a disciplinary hearing, and then ultimately, you know, there needs to be something in your policies and procedures, a disciplinary code, which justifies suspension without pay. Now, that is when someone breaks a rule, and you can't just off the bat decide, well, okay, I'm going to tell this person they need to sit at home and be without pay for a couple of days because they didn't follow my policies. But now if someone is exposed and they're unable to work as a result of having to self-isolate, then we need to also draw a distinction between, is a person able to still work from home? Then in the ordinary course of events, they would do their job, they would perform their duties, they'd still be remunerated accordingly. Only in the event where, you know, they are then not able to work from home, they've been exposed, but they haven't been booked off, they haven't been tested positive, and they haven't been determined to be incapacitated, then would it be unpaid leave. But in the event that a doctor has determined, okay, they are ill, they can't work because of COVID, then it would be treated as sick leave. So there are different permutations that could arise in that circumstance.
Now, Justin, something related, but not to do with disciplinary processes, but maybe to do with the vaccine when they do become available. Can employees demand that their employers actually procure the vaccines for them, for the safety of the work environment?
Sure. This is becoming increasingly controversial these days, the issue of vaccines and whether an employer can force someone to do that. Now, at the outset, what I need to point out is that no employee can be forced to undergo any form of medical procedure, medical testing, or whatever it might be. A vaccine would fall under that. However, if an employer implements a policy, a pandemic policy, as we've alluded to earlier, and that requires people to go for a vaccine, to produce a certificate showing that they have procured that vaccine in order to be able to enter the workplace, and an employee unreasonably refuses to follow that, it might so be then that an employer could take disciplinary action. But once again, we need to talk about what is reasonable. So is there a medical reason why the person is unable to take that vaccine or refuses to take it? Is there a religious reason? And also then, once again, we look at, okay, does the employer say off the bat immediately, no, okay, that's it. I know I have my policy in place. You've agreed to it earlier. Now you're unreasonably refusing. That's it. I'm going to take disciplinary action against you. We also then look, can the employer accommodate this person? Because they might have certain, as I said, religious beliefs or medical reasons why they can't take the vaccine. Can they be put in an office where they are isolated from everyone and still perform their duties, or could they work from home? So once again, we weigh it up. We look at, is there a pandemic policy in place that asks for it? Is there a good reason for having the requirement that a vaccine certificate is produced in order to get to work? And if we answer yes to all of those, and an employee unreasonably refuses, despite earlier agreeing to the terms and conditions of employment, it could so be then that they could be disciplined for breach of contract and gross insubordination.
Yeah, but my question also went the other way around. Can the employees themselves, for example, demand that their employer procure vaccines on their behalf?
I suppose that question would really depend on what kind of environments does the business operate in. So if it is client-facing, if it is a public business like a restaurant where you have a lot of foot traffic and you are exposed to a lot of risk, it could so be that it would be a reasonable demand from employees, because at the end of the day, an employer would have a genuine interest in making sure that their employees are protected from the pandemic. So it once again depends on reasonableness and also what is the employer willing to do. And as I said before, I wouldn't think that any employer would not have an interest in ensuring the health and safety of their employees and then going as far as making those available to the employees at their own cost.
Goodness me, uncharted territory. I mean, as far as the pandemic is concerned, but I suppose as far as the legal matters as well are concerned. Legal advisor there at Strata-g Labor Solutions, Justin Hattingh. Appreciate your time. Thank you very much for helping us through this conversation tonight.